Neve and Steele, how are you guys?
Great.
Good. How are you, Ryan?
I'm doing good. And here we are. We got three people again. Steve, you and I are going to figure out how to dance a little bit better, and we're going to keep this going. I'm very excited to have Neil on the podcast here. You guys have been working together, and Steve, I think you said you guys have known each other for quite a while, huh?
We really have I don't know how far back we go, Neil, but it's well over 15 years with our Minnesota connection, right?
Absolutely.
So, Neil, why don't you, for the listeners, just give us a little bit of your background and what you currently are at work, what the company is that you're working for, and what you guys do.
Sure, happy to do that, Ryan. I won't cover my entire work experience. It'll take the entire time of the podcast. I'll just go back 17 years, which is when I started doing ESOP trustee work in 2005. I am a licensed CPA with the state of Minnesota. I've done a lot of work before I started doing the ESOP trustee work. But in 2005, the company I work for, the head of the wealth management group asked me to start selling ESOP trustee services, which is what he had provided in another bank he came from. And our trust department was providing all kinds of trustee services except ESOPs. So it was kind of a natural growth trajectory for us. And so from 2005 to middle of 2010, I developed a modest ESOP practice at that bank. And when I needed to hire more people, the response I got was, too bad, the bank has a hiring freeze. And so I didn't want to stay at that point. So I joined another bank, Bankers Trust Company down in Des Moines, Iowa, that had been in the ESOP trustee business for a number of years, but they were looking to expand at a national level, which is what I had developed in my short practice. And so I joined them in the summer of 2010, stayed in Minneapolis, working out of my home. And from 2010 till the spring of 2016, we more than quadrupled their ESOP trustee business, became really well known in the ESOP trustee space. But I used to say unfortunately, but I think it's now fortunately, the owners of the bank, it was privately owned, decided that they didn't want to provide ESOP trustee services anymore. They wanted to stay as an ESOP lender, and you really can't do both on a national level. So they then sold their ESOP trustee practice to the largest ESOP trustee in the country. And at that point, my wife and I decided why don't we do our own business providing ESOP trustee services, in which I operate as an individual trustee / fiduciary. And from the summer of 2016 to now, we've gone from 3 people to 16 employees.
Wow.
We've always been a virtual company. 3 of our people are in San Diego, and trust me, they're not moving to Minneapolis. And even the fellow in Grand Rapids, Michigan, he's not moving to Minneapolis. And the rest of us are in Minneapolis. So, we were very fortunate to be prepared for the pandemic in terms of communication well before there was an issue. But nonetheless, we now have 16 employees. We have 142 ongoing clients in 29 states. We have more in California than any other state. Second is Minnesota. Third might be Ohio. But we don't look for a particular client in terms of where their location is or industry. All of our business, Ryan, comes on referrals from other ESOP professionals. So whether it's ESOP valuation firms, ESOP lawyers, there are a number of firms that are dedicated, kind of like ESOP investment bankers. That's where we get all our business from. And then you look at the industries of our clients, we probably have, if you look at every type of construction company, including general contractors, subcontractors, we probably have more in the construction field than any other field, but not by a lot. I think it's quite similar to if you look at the statistics from the National Center for Employee Ownership in terms of the industries, we really fall in the lines like everyone else. Construction, typically 1, manufacturing 2, distribution 3.
I never knew construction was that high, to be honest. Interesting.
Well, it is. If you look at what are their options to sell? Who are they going to sell it to? Maybe a competitor. Private equity typically doesn't want to get into construction unless it's incredibly large. So their options are limited.
Interesting. So Neil, what is maybe give us a quick overview of the types of services you guys provide, whether it's associated with the transaction, ongoing, because then once you give us the broad overview, then we can kind of go back. And when Steve was talking with Dave Deal, we were talking about the transactions. Maybe then we can talk about the kind of the sequential order. Steve, any thoughts on that?
I think that's good. If you want to just really briefly talk about what a trustee does.
Mm-hmm.
What is a fiduciary? I think people know fiduciary, but what is the main thing that the trustee in an ESOP transaction or ongoing does?
Yeah, let's use the term trustee. And I think fiduciary is a better term, which people probably recognize. Essentially means I'm looking out on behalf of other people's interests. So in the ESOP context, for example, in a transaction, which is one major form of services we provide, the transactions primarily relate to the ESOP purchasing stock in the company. And the company could be a minority purchase, it could be 100%, it could be in between, but it's an ESOP purchase. And that's typically where we'll do 75% of our transactions in a given year. The second largest category of transactions are that when the ESOP company is sold to a third party. ESOP companies get sold just like any other business for a lot of different reasons. And that is the second major category of transactions that we do. And transactions essentially are a limited term engagement with a specific purpose. And theoretically, when that transaction is complete, that engagement is complete. But fortunately for new formations, then there's the opportunity to become the ongoing trustee. And what's interesting, I think, in particular, is that there is no legal requirement that the trustee for an ESOP or any other retirement plan be an independent party.
Mm-hmm.
I think if you look at most 401k plans in particular, you'll see, the owner of the company, major shareholder, is the trustee, and then they'll hire a custodian that does most of the work and holds the securities. In the ESOP world, the majority of transactions where there is the greatest risk are done by independent trustees. In terms of the ongoing trustee, it's still amazing to me that more than half of all ESOP trustees for ongoing companies are internal, and it's usually a committee of 2 or 3 of the employees of the company. Now, the risk is much greater in the transaction.
I was going to say, give us the risk of that, Neil. Like, why in God's name would anybody want to do that?
I had no idea it was that high still. I thought it was starting to come way down from there.
No, I mean, it just takes a long time. But for example, I think that of the new formations that we do, we get hired 90% of the time as the ongoing trustee. But if you look at risk, the greatest risk and where most of the lawsuits happen are in transactions.
Mm-hmm.
And so people are willing to spend the money there. And then sometimes they get a little cheap after the transaction's done. And they say, look, why should I pay you when I can have my employees do this for nothing?
Oh.
Well, it's a challenge. And, there have been some lawsuits coming out of the ongoing opportunity. And it really happens in that case if there's a significant decline in value of the stock. And I guarantee you everyone gets sued if there's a bankruptcy. But beyond that, I mean, most of the litigation cases that we see come out of transactions. And that's why people don't see it as much of a risk ongoing. And they also wrongly assume that, oh my God, we've got an expert valuation firm. What do we care? Well, they care. They should care a lot because the trustee cannot just accept that report. The trustee has to review that report, challenge the assumptions, and the trustee is the one that says, yes, I agree with that recommendation in the draft report.
That's awesome.
So that's kind of an overview.
That's fantastic, Neil. And I want to come back to like ongoing operations and your involvement and how that like works with the board and the ongoing evaluations and such. But because you were talking about where most of the legal ramifications are on the transaction, let's go back up and talk about on the transaction. How do you get involved in that? What are your roles in the transaction, and where do those legal issues arise from?
Yeah, great questions, Ryan. To begin with, the trustee is usually the last person hired, except maybe head of third-party administrator. But we're down the food chain because typically, let's say Steve is a business owner and the CPA has told him, hey, I've got this great option for you in terms of your succession planning and a way for you to slow down and maybe get some liquidity out of your business. And so if the CPA tells Steve, yeah, you should go talk to John Smith at this law firm, or you should go see the people at this valuation firm, because you really, Steve needs to start by figuring out how much his business is worth, not just in his own mind and not just by rule of thumbs, because every business owner thinks their business is worth more than it really is, but to get a realistic perspective on the value of the company. And so they usually will start with getting a feasibility study done by a valuation firm. Now, the valuation firms are also, they're really doing a comparison for the owner of, what's their net cash and the advantages of selling to an ESOP versus selling to a third party. So they're kind of laying all that out. And then when, let's say, Steve gets done with that and he says, man, I think selling it to the employees of the ESOP is really what I want to do. I still want to work a little bit, or maybe a little bit more than a little. I still want to be the CEO. I want to be the chairman of the board. I know I've got to finance a good portion of the deal. I want to watch what's happening, and I want to reward my employees that help me grow the business. And so this is a great option for me. Once Steve makes that decision, then that valuation firm typically will lead the charge and be kind of the facilitator for the transaction.
And you're not representing the seller, you're representing the future employees in the trust.
Well, I'm talking about the company advisor, the person the person that's advising Steve, the business owner. So they're kind of like an ESOP investment banker or a company financial advisor, and they lead the process. And one of the first things that they do is they'll set up interviews with trustees. And, typically we'll get an RFP that we need to complete. We'll get, a time for an interview. And so we go through that process of being one of at least 3 potential trustees to be interviewed, because the board is the one that hires the trustee, and this is a fiduciary decision. So, for example, as much as I'd like people to say, well, just hire Neil and be done with it because he'll do a great job, they really shouldn't do that as much as I'd like them to. So it's a fiduciary process, and so we want them to go through that process. And, and then if we find out we win it, then we've got to get our engagement letter put together. We have to get our advisors put together and get their engagement letters put together. And then once those engagement letters are negotiated and signed, then we can begin the transaction. Now, to your question is, what do I do during the transaction? It's really simple. The trustee in the new ESOP purchase is the buyer of the company on behalf of the trust and the participants. So it's my decision. I'm not asking the participants for their input, but what I'm doing is on their behalf, which is why I'm a fiduciary at that point.
Neil brings up a really good point that we talked a little bit about with Dave Deal. Is an ESOP, and you said this, Ryan. It's still a sale. You've got a buyer and a seller, and the seller is represented. And the point that Neil made, and I think it's lost sometimes, is that the company is hiring Neil. The board of directors is hiring the trustee to represent the employees, rather than, Dave Deal could say, hey, I work with Neil all the time, or I work with so-and-so all the time. He's a good trustee. You should work with him. I think that independence is important, but it's still just a buyer and a seller.
Well, that's what I love about this podcast right now, because the amount of hundreds of people have been through our trainings over the years, and we always talk about the trustee, and it's this fictitious human being up in the clouds that has some say on their business. But to your point, you're a real human being that is going and representing a bunch of people to pay fair value for a company. I mean, it's really. I like to think of
myself more as the Wizard of Oz.
There you go, behind the curtain, right? That's awesome.
I mean, to some degree, sometimes when we do presentations after the transaction takes place, I mean, I may not have to say much, but it's good for the people to see, hey, yeah, this is the guy that's the trustee. This is the guy who represents us.
So let's talk a little bit about the negotiation on the buy side. So you're hiring your financial advisor / investment banker, the attorney and CPA firm, your team of advisors. What's the dialogue with the seller and their advisors?
Yeah, the process is pretty well identified. And the initial statement I'm going to make, it's going to sound odd. In an ESOP transaction, the seller typically puts out the first offer. And so that's different than non-ESOP for M&A, but it's kind of been always done that way. I'm not sure why, but it has been.
I just love it because you create the board as the seller.
No,
the board. As a seller, you're not creating that board that hires you?
Well, we'll come back to that in a moment.
Okay.
But yeah, the point is that, so the term sheet comes to us from the sellers, and there's probably, we've tried to make this a more efficient process instead of having, 14 pages of red line documents, red line, green line, blue line. You can't follow what's happening. And being a CPA at heart and numbers cruncher, many years ago, I put the negotiation into a basic Excel spreadsheet.
No way. I'm a CPA doing that?
I put the 20 or 25 items, and then each column then represents an offer, counter offer. So number one, we know where we're coming from. More importantly, then we've shown the Department of Labor that this truly is a negotiated process between a willing buyer and willing seller to dispel their ridiculous notions that we don't negotiate the deal. So what happens that is, in terms of the process, is that we get the seller's term sheet. After we get the draft valuation report from my valuation firm, we present it to my advisory board. I also do something which is a little different. I have a second valuation firm kind of do a high-level peer review because, I just want to make sure that I have multiple eyes looking in this in different perspectives. And then once we present it to my advisory board, then we as a trustee team, my valuation firm, my lawyer, we'll stay on the call and develop our counter.
Got it.
And, and then we might present the counter offer from my attorney to the company's attorney, the next day or two. And then they get it back and then they mark it up and they'll give us back their, here's column 3 in this negotiation spreadsheet. Then I'll get together with, again, the trustee team and we'll look at it and see, okay, we've got these that we have agreed to. Here's the remaining items. What do we want our counter to be? And then we'll go back and forth that way until we have everything agreed to.
And it makes a bunch of sense. When I was talking about, so I was thinking about the seller's board, the eventual board. But like what I think is so beautiful about it is like the seller and their advisor are interviewing you, hiring you, and then they're bringing the first offer to you, and then you're going back and forth. And to Steve, your constant comment, a friendly negotiation.
It's just such a different. I'm not an M&A person, but it's such a different feel, and that we talked about that before. It's still negotiation, but it's just such a different type of negotiation than an M&A. I don't know if you can call it friendly negotiation. Would you call it friendly negotiations, Neil?
Yeah,
and that's what I refer to it as.
First of all, it's friendly because all the advisors, whether they're for the seller or for the trustee, we all know each other. Mm-hmm. And on day one, the advisors to the company could be, day 2, they could be my advisors in a different transaction. So we also, when I look to select an advisor for either a valuation firm or a law firm, I look at who the advisors are on the other side and find people that are compatible with them. We don't need people that are, going to be difficult, don't play well in the sandbox. This is just a friendly negotiation, but we are adversaries. We are on opposite sides. And to the extent if you say that, the seller wants to get as much as they can, that's probably true. But, we hear a lot of owners say, I don't, want the highest price. And then from my perspective as a trustee, as a buyer, I want to pay the lowest price. But again, what is the lowest price going to be? It's no good if it's low and they won't sell.
Again, it's all predicated on building a good, healthy business with good, sustainable, predictable, transferable cash flow. Then you're just assessing the value of that cash flow. And so, Neil, where are some of before we move on to the ongoing operational oversight as a trustee, what are some of those the legal issues that might arise during that transaction?
Yeah, there's 2 issues. The legal issues that might arise during the transaction are normal negotiations. So whether they have to notify, key customers, key suppliers that there's a change of control, whether they need permission from vendors to change the ownership. What kind of contracts do they have? Do they have to be renewed for whatever reason? Do they have any potential liability issues from their facilities? So the legal issues from a transaction are no different than any other transaction. Do they have employment contracts with key executives?
Anything associated with a stock sale, right? And with all the liabilities that are coming with the stock sale, you just got to tear through all that to make sure that you know what you're buying, right?
Yeah, we do, and we don't hire a CPA firm, an accounting firm, to go in and review the books. We do a reasonable amount of due diligence and really rely on what we put in the stock purchase agreement in terms of indemnifications that we expect them to fulfill and cover.
Awesome. So what I'm thinking about is switching towards the ongoing, Neil, is like the amount of questions that I get about like, hey, what's this trustee? So first of all, and Steve and I are doing another episode about debunking a lot of the myths. But so wait a second, everybody's going to have a voice, and the forklift driver is going to be, given the strategic direction. This trustee that I don't know is going to be telling me how to run my company. You've probably heard those statements before. So let's talk about your ongoing role as a trustee, and what does that involvement look like?
Sure. First of all, the participants don't get a say in managing the company just because they're an employee owner. That's why the word employee comes first. They're an employee first, and they're an owner to some degree, like owning a public stock. They have limited rights. The difference, of course, between owning public stock and being an ESOP participant is that they can impact the value in terms of how they do their job. And more importantly, the growth is likely to be more substantial. But putting that aside, what I'd say is that the ESOP trustee, no matter what ownership the company has, but let's focus on 100% ESOP owned, is the most passive shareholder you can imagine. The ESOP trustee will typically, unless they're an internal trustee, I will never serve on the board of a client. We will never tell management what to do. And ultimately, we want a partnership with the board of directors. Our job is oversight. It's not managing. And I kind of kiddingly say, but not kiddingly say to any prospect, look, here's how we operate. And if I cross the line, fire me. You've got a 30-day cancellation notice in my agreement. I shouldn't cross the line. And, that's the way it should be.
So if that's the case, if you're that passive, why is a trustee needed? What role do you really serve in the eyes of regulations? If you're not, I think that's where the confusion comes. Like, well, if I have this trustee, they're supposed to help us with management. They tell us what to do, and I don't want that. That's why I don't want an ESOP, and that's so far from the case. But then the other side is, well, then what are you doing?
All I think it was that scene from The Office Space where he's like, so what do you do? No, I'm just kidding.
So what do you do?
I think part of the issue is the confusion right there, Steve, that people believe that as a sole shareholder, you've got a business owner who hasn't worked for anyone else for 30 years, and they fear a loss of control, which is absolutely not true, but that's what they fear. And that's, in fact, one of the reasons why they may have an internal trustee, because the internal trustee works for them, and so they feel that they're not losing control, even though they should to some degree. But I think to answer your question more directly, the most important thing that I do as the ongoing trustee is, number one, monitor the board. We want to make sure the board is doing their job. And whether that's overseeing the financial performance of the company, whether it's overseeing the CEO, whether it is reviewing and approving budgets or projections, it's holding the management team accountable. And that's something that we clearly want to make sure the board's doing. Now, I think that from a practical standpoint, the most important thing the trustee does is set the value for the shares owned by the trust on the last day of the plan year every year. So when the participants eventually get their statements, and their statements are only once a year, not quarterly like 401k plans, you can't go online and look up the interim value of ABC company because there is no such thing in terms of interim value. It's only valued once a year, and the participants get their statements anywhere from 4 to 6 months after year end. But that share price that's in their statement that then shows their balance is what the trustee sets. Now, we set it with the help of the valuation firm, who again give us their draft report that we review, but the trustee accepts that value.
And that would be like the Dave Deals of the world who do it, like and for the listeners when we were talking about the 400 valuation updates that they're doing, they're then, supplying that to you then, Neil. And I'm assuming, I shouldn't assume, but like I can imagine that a lot of what you're doing is also holding a liability, because if it's their employee doing, as a trustee, the liability has got to be crazy. So I'm assuming you in the process in your role is, the checks and balances, and as at least they're getting value for the liability you're holding for that opinion. Is that true?
Yeah, by setting the value, they've transferred that risk to me.
Got it. And I always joke around, Neil, like, because when people are like, so what does a trustee like they'll step in if all of a sudden you're a consulting firm and then you're just all of a sudden decide to become a plastic straw manufacturer in California. Like, don't do that. Or if like all of a sudden your company's using all of its funds to buy, Bitcoin. So it's
again, board of directors is the one that is the primary line to stop that from happening. The board has to have that responsibility. The board, to be able to buy another business and go a totally different direction. The board better be the one that, looks after that and decides whether or not that's appropriate, because for me to get to that point is probably too late.
Well, and I think this is where, and Steve, feel free to jump in here. Is like, so like how the board is formed, like there's a lot of narratives out there, Neil, and a couple recently on my show. It was this gentleman, Brent B. Short, love the gentleman. They got this thing called permanent equity where they have a long hold period. And his whole thing is, well, with ESOPs, the management and the company become stale because they're worried about paying off debt and they're not focused on continuing to innovate. But my always rebuttal is, well, it's the board. It's the board's fault. It's not the ESOP's fault. So like, what is your interaction with the board as far as like, as they're continuing to evolve and grow their company? What's that dialogue like?
Well, I mean, to begin with, we will participate in at least 1 or 2 board meetings a year. And where there is a guest, an observer, there's nothing to vote on. But we want to see what's happening. Number one, it allows us to fulfill our duty to monitor the board. But more importantly, we want to learn more about the company in those board meetings than we would any other situation. So number one, we're going to attend at least 1 board meeting a year, maybe more. Secondly, we get the board reports at the same time that the board members get their reports. So it gives us a chance to see the material. I don't require any special reporting for clients. I don't require, quarterly meetings with the senior management team to tell us how they're doing. No, I mean, that's what the board does. I mean, we'll occasionally have contact with the CEO or CFO for different reasons as questions come up, but it's not a regular basis where they report to us.
And I think, Ryan, to your point about the board, the company being stagnant or the ESOP causing this, I would say the opposite. One of the experiences I've had is to watch a brand new ESOP and watch the new board members or watch the management team that came onto the board, and now having someone else come in and value the company, and whether that's the trustee with part of those discussions or it's the valuation firm, but together they're starting to see things and see how value is created that they may never have known before because they're having to go through evaluation. And it's amazing to see them as they grow as managers and CEOs and CFOs to say, well, wait a second, it's not all about growing, the share price. It's how can we get better? Oh, wow, if we did this, that's going to affect, or, we think your business is worth more because you guys decided to diversify your client base. Well, who shouldn't do that?
Mm-hmm.
So I think if it's done right and the board pays attention to it and has a good trustee, has a good valuation firm, I think it does the opposite than what other people might say.
I could totally, that would be my assumption too. And like what would make the most sense for probably the 80%, but like what happens when the internal management is the board and they have been there forever and they're just kind of like, how do you shake that up in a way that's healthy for the rest of the employees versus just having the people that have, got a big ESOP accounts, have been there for a long time? Like, how do you approach that dynamic?
Well, I think it's an interesting question because, again, if we're starting with the new ESOP, that board will have some number of independent directors right from the beginning, the day after or up to a year after the transaction. So, for example, I will want to have at least 1 independent director on a 3-person board. And that's what I'll ultimately negotiate for. I'd want to have 2 independent directors on a 5-person board. So we want some number of independent directors from the beginning, and we give them time, 6 months to maybe find the first independent director, 12 months to find the second. So they don't have to have it the day after the transaction. But no, they have to have some number of independent directors for a variety of reasons. Number one, I think it's a best practice. I mean, personally, if it was up to me, I would have them require a majority of the boards to be independent. That's my personal perspective, that I've seen much more effective boards when you have the majority are independent than the opposite. And I think if you have, all inside board members, which is probably a carryover from practices in the past rather than what's happening now, I think that is a troublesome dynamic because especially when you've got a CEO who is, a big personality, I mean, how likely is it that people that work for that CEO are going to disagree?
Not often.
Because their disagreement could risk their job. Now, I mean, I had one of my former clients, they had all inside board members. They made a couple of acquisitions and the former owners of those companies were on the board. And they were kind of surprised in how this, board meeting operated with all, the management team, because it really wasn't a board. And so they started asking questions and creating challenges for the CEO. I mean, at one point they had done had the CEO go for, get some performance reviews done, whatever type they were. And then they got the results back, and not surprisingly, it wasn't particularly positive. So one of the board members called me to discuss what to do, and I was not the trustee any longer. I said, look, here's the deal. I mean, you are specifically have duties as a board member, regardless of your position as an employee. And you are obligated to do something with those results, and doing nothing is not acceptable. Now, what I suggested, though, is number one, don't go in by yourself to talk to the CEO.
Come up with a plan.
I said, and realistically, knowing the CEO, he's going to ignore it anyway. But I think that's a problem when you have an all-inside board. It's very difficult.
And Ryan, we talk about ESOPs that you said it earlier in the podcast. They are worried that someone else is going to come in and tell them how to run their business, how to control their business. There's no day-to-day control run by a trustee. But if you're going to sell your company 100% into the ESOP, there has to be something that's given up, right?
Mm-hmm.
Like, I mean, you're not going to sell to the employees and be 100% in charge of everything, still the CEO, still the chairman, and not have some oversight, because it used to be you and your husband or you and your wife that ran the company. There was no board. There is change,
Mm-hmm.
but it's not day-to-day change. It's change for good. I mean, we're trying to manage this company for employees.
Well, you just nailed it, Steve. And so, Neil, I just did in an interview a few weeks ago with this woman that's second generation, passing the company on to the third generation family business, and they have the exact same structure. Like, they're one of like the 2% of or 3% of family businesses that make it to third gen, because they have the governance, they got the board, there's management. It's all like everything that you just described is why they're continuing to succeed. So, like, to your point, Steve, I think it's there's this false notion that, like, hey, we have to give up all this stuff, but it's really just, you're just becoming a better company.
Becoming a better company. Good way to put it.
One of the more pleasant things that we see is that people who resist adding independent directors, they can only resist so long if they want to complete the transaction, and they're not believers, to say the least. And I think most of those people, assuming they get the right board members, people who truly are qualified, not someone who's just filling an empty seat because they're meet the definition of independent. I think the vast majority of owners are thrilled when they get the right independent directors on it, and the comments are such that I wish I would have done this sooner.
Mm-hmm. I have a client where they got someone from private equity onto their board to help kind of shake things up. They've been in ESOP for 30 years, and it's like, hey, like, they're thinking about business a little bit different. They're just challenging them, which is healthy, right?
Yeah. The other thing that happens, do keep in mind that the vast majority of private companies that then the owner sells to an ESOP, they have typically no debt, and they've had no debt for some time. Now we're going to a fully leveraged situation. Now, clearly, we want to make sure it cash flows before we close the transaction, but it's a different dynamic and different pressure on the company to make sure that cash flow continues to pay down the debt as required.
Building a good company with good cash flow, like, what a concept, right? Neil, as we're wrapping up here, what is something that I'd say a couple of questions, and Steve, feel free to jump in, is like, what do you see that works really well? Like, when someone's like running all cylinders, and you explain, maybe tell us a story, like when you jump into an annual meeting, you're like, hey, these people are really doing the right things. Like, anything in particular, any couple key findings that you'd be able to pull out? Yeah,
I mean, keep in mind that when we have that rollout meeting and these employees now are told they're now employee owners, they're beneficial owners, and they walk away wondering what happened. And then they don't get their first statement until a year and a half later, and it's pretty underwhelming. I think it's really important to have clear-cut expectations that are realistic, that this is a retirement plan, not a get-rich-quick scheme, and that it will take maybe 4 to 5 years before their balances get above $10,000. But the reality is that the longer someone stays at a successful employee-owned company, the greater their retirement balance will be. One of the best stories I heard from a retired participant, one of my clients, was that she's been with the company for 25 years. She had recently retired. The ESOP bought into the company 21 years ago, so she was there from the very beginning. And Steve, you'll enjoy this. She actually kept her initial participant statement.
Oh, awesome.
And that initial
Good for her.
participant statement said like $620 something in value, whether it was fully vested or not. I doubted it was, but this is your, it was full account, 600, maybe nothing vested. Then when she retired, she had over $1.5 million in her account.
Oh, that is freaking awesome.
And her life is exactly the way it's beyond what she expected it would be, because clearly she can retire on that money. Now, not everyone's going to have that success story, trust me, but there's a lot more of wonderful success stories where people end up with a retirement account balance that's a multiple of their annual salary.
That's so cool.
And there's not likely any other way, any other retirement plan that they could accomplish that, or probably no other way legally they could accomplish that as well.
Yeah, good caveat there.
But I mean, it truly is an opportunity that many people have been able to realize, and so many more can.
And Ryan, I think Neil hit on the retirement side, and you work for a company for 20 years. They take great care of you, probably better than maybe even a defined benefit plan with that kind of balance. I know we're running short on time, but I think we should at least leave the listeners with one other concept, and that is that ESOPs have been really thriving since late 90s. And one of the things we're seeing in the industry is that these companies are now hitting the radar, and have been for 5 or 6 years, hitting the radar of other companies saying, hey, I want to go out and buy a good company. Well, maybe ESOPs are good companies. We keep talking about how good they are, and other people are finding that out. And so some of these benefits that employees are reaping are because the businesses are being sold. And without going into really great detail, Neil, is what's happening in the industry, and what is your role when that happens, when a company with a bona fide offer comes in? You said that some of your transactions are happening on the other side. Can you just touch briefly on that?
Yeah. First of all, the trustee has nothing to do with the sale of the company until the board has signed an LOI, and then the trustee's role actually begins. So no one knows who the trustee is, so no one's going to send me an unsolicited offer, because they don't know who the trustee is. But they know who the board members are, or they know who the management team is, whether it's from their website or their trade industry. And so a lot of clients get unsolicited offers on a regular basis. They used to come in via fax from brokers. I don't think they're coming in that way anymore. But they get a lot of unsolicited offers. And the first thing that we suggest to our clients is they need to have a policy on how to deal with those unsolicited offers. So there's no question what the CEO has to do when he gets one.
Nice.
Now, the fact that you get an unsolicited offer doesn't mean you have to respond. They could say, yeah, well, we're willing to pay you 8 times trailing 12 months EBITDA. It's like, right, I don't quite believe that. But it sounds enticing. But Steve used the word bona fide offer. I mean, basically, I think a board only has to respond to truly a bona fide offer, which is someone that has the ability and the financial ability to complete the purchase that they're contemplating. Someone that may have done this before. Someone's a credible buyer, not a broker, not someone that represents someone else initially, and someone that also knows how to purchase an employee-owned company, which is a little different than non-ESOP companies.
It's really interesting you bring that up, Neil and Steve, is that because that's what happened to my partners, where they actually engaged, and then they got that offer from a private equity firm, and the trustee was their offer was more than the forecasted 5-year equity target. So they were essentially strongly or even told by the trustee, say, hey, like, you will have liability here if you don't accept this because of how great the value offer is based on your forecast. I mean, is that something that you've ever been involved in, Neil?
Well, I mean, the decision to ultimately sell or approve the transaction from the trustee, number one, if it's a sale of stock, it's just the trustee. If it's a sale of assets, there's a pass-through vote to participants, and they provide direction to the trustee based on the shares in their account. And the trustee does not require to follow the direction, but typically does. But what I think that the issue is, it's, the Department of Labor, which sadly doesn't have many regulations for what we do, they have put out a pronouncement many years ago that did say, just because you've got an offer that's a premium doesn't mean you have to sell. Number one. Number two, the board can choose can use their business judgment rule, and they can choose not to sell it to anyone for any reason they want to.
Got
it's
it.
good to have a good reason, like, they're going to fire employees, they're going to move the business to another city, the cultures don't fit. But I mean, they don't have to have a specific reason. It could be just those things I mentioned. The trustee can never consider that. So in terms of what the trustee does, I mean, it's an investment decision.
Mm-hmm.
Are the participants, is the trust better off taking this offer, comparing that to the near-term growth in share price? And if the current offer is better than that, great, that's in favor of sale. If the company, despite knowing that there's, risk in terms of achieving the projections, but if the company is likely to achieve those and that value is greater, I mean, there's certainly an execution risk, but in that situation, the typically trustee will vote not to sell.
You know what I love about all this is it's just so rooted in common sense. And like, there's a lot of complexities to make the common sense happen, but like, I don't know, everything you just said made a bunch of sense. And it's, I don't know. I appreciate that so much, Neil, because these topics are ones that constantly are just Googled, and, as well as I do, there's 20,000 pages of Google that have different perspectives on this, whether it's an 800-word blog from some random advisor out there. So it's nice to just hear from your perspective on actually what's going on behind the scenes. Steve, any other questions for Neil before we wrap up?
Yeah, let me go back a moment to the unsolicited offer. Let's say, the most important issue for me, if the board does negotiate that unsolicited offer and get to a point, is how do you know that's the best price they can get? And we also know that if we say to them, okay, now we want you to run a full and open process, I mean, they'll lose that current buyer, and then they'll let many people know that they're for sale, which they don't want to do. So we really have to be careful in getting comfortable if in accepting an unsolicited offer, and that's the only one. We need the company, the trustee and the valuation firm have to get comfortable that this is not necessarily the ultimate best price, but this is darn good. Now, whether it's an all-cash offer, whether it doesn't include an earn-out, I mean, there are factors to consider, but that's an important element of the process.
I love it. And again, whether it's just one owner or the ESOP, they should do that just like you said anyway.
Absolutely.
Exactly what I was going to say before Neil jumped backwards was it's common sense, like you said, Ryan, that it's whether you're Neil he's not the owner, so I don't want to say that, but he's thinking just like if I owned a business, I should be thinking the exact same things. Is today the time to sell? Is this a high enough offer? I mean, all the things you just said, Neil, that's what I'm doing as a sole business owner, right? Like,
I love it.
Common sense.
Yeah, and the other thing we need to be careful about in an ESOP sale like that is that, that the management team is not getting a incredible new employment contract or getting bonuses that are taking away shareholder dollars.
Yep, totally agree. So, Neil, what is the best place for our listeners to get in touch with you?
The website for our company is venturaesop.com. And my email address is the best way to reach me since I travel a bit, is nbrosen@venturaesop.com.
Steve and Neil, thank you so much for coming on and doing this part of the episode. I really enjoyed the conversations.
Yeah, thanks, Neil. I appreciate it.
You bet. Thank you, Ryan. Thank you, Steve. Have a great day, everybody.
Good morning, David, and good morning, Steve. And I'll let David go first because Steve and I are learning. Good morning, David. How are you?
Good morning. Good morning, Ryan. Hello, Steve.
Good morning, Steve. Now it's your turn.
It's my turn. Hey, Ryan. Good to see you again.
Yes, I'm very excited to keep diving into the Employee Ownership Month. And David, I appreciate you coming onto the show. And why don't you just, for our listeners who are not familiar with you and your firm and your practice, why don't you just give us a brief overview of your background in the firm, and then we'll kick into it.
Sure, happy to. Thank you, Ryan. So I'm seated in Chicago. We're with a law firm here that was founded in 1999. The firm name is Levenfeld Pearlstein, and we're about 105 now lawyers. And we have offices in a variety of cities across the country. The COVID pandemic and intentional growth has led us to be able to expand and spread our wings a bit outside of the Chicago area where we were founded. So we do a lot of work with business owners. ESOPs is one aspect of our advisory service for business owners that are looking for ways to transition their ownership of their business. There's many ways to do it. ESOP is one of them. So that's one of our main service offerings here at the firm. I've been doing this sort of work for about 30 years. It's hard to believe that I'm that old, but I'm getting there. And one of the great joys of my career has been to work with companies that have used this very underutilized tool called an ESOP to transition ownership of their business. There's lots of ways to sell a company, but I've found in my career that the happiest deals we do are when people decide to use the ESOP as their strategy. It doesn't work for everybody, but when it does, it's a beautiful thing. So I've been blessed to have a really great career advising really terrific companies and doing something that's very special for themselves, their families, and their employees. So very happy to be here and share whatever you find is wisdom or knowledge to your audience.
That's awesome. And I won't go too far down the rabbit hole of the happiest transactions, because I can imagine that there's a lot of a lot of context of not happy transactions. But I'm super curious, David, like how in your legal career, like how did you come and stumble across ESOPs, and why did you decide to continue going down this route?
Sometimes life happens by accident, and certainly that happened for me. I was working for a bank. One of the largest ESOP, what we call trustees in the market, was the successor to the business in the bank where I was working. And I just so happened to be in a rotational program for a period of 4 to 6 months. And I got plunked there probably on one of my last rotations and said, you're gonna be involved with this sort of work. And we have this very small group that manages ESOP companies. And I had no idea what that meant. So where it came out of a happy accident grew into a 30-year career. We worked with a lot of large public companies back in the early 80s, or late 80s, I should say. In the early 90s, a lot of ESOP, what we call ESOP ownership or employee ownership, was at very large companies. Colgate Palmolive, Inland Steel. And we were managing a very small portfolio of retirement plans for those kinds of companies that were put in place mainly to protect themselves from corporate takeovers. It was a much different world, and grew out of that just a passion and some opportunities to work with other great service providers that brought this to the lower and upper middle market from the public company sphere. And it became much more popular over a period of time when some of the tax laws changed back in the late 90s to make it even more favorable for business owners that were thinking of using an ESOP. So it really, like I said earlier, it was very much an accident, but lucky it happened to me, and it's been just a great ride.
I'm so lucky because of how long you have been doing this, Steve and David, and some of the people have been on this show. I mean, people have been, slogging this through for the decades and watching as the momentum's grown. It's pretty cool to watch. I can only imagine, as being in it for as long as you have, watching the momentum go, watch the interest grow, and as things have evolved, it's pretty cool. And so, Steve, as we start diving into this topic today, and what I was thinking about, just kind of having David give a quick overview of just kind of the legal role in the ESOP, and then maybe right before he does that, you want to kind of just give the listeners a quick overview of kind of what we're going to be tackling in the topics that David's going to be covering.
Sure. So I think the main thing is to give that legal. How's an attorney involved in this? We talked a lot about the team. We've done a couple of these podcasts about the team, the trustee, the lending. I think it's important to know, what does an attorney do in this process, both on the buy and the sell standpoint. So I think we could start there, definitely. I know David does work on both the buy side and the sell side. But then once we get done with that, I think we really want to touch on just a few basic things, questions that are asked about how an ESOP operates, what the legal document does and does not do. Not get too deep into it, but just maybe a little bit deeper than some of the other things that we talk about. So, yeah, I think if we just, I think we want to start there.
Yeah, and David, as you're going down the route of like the legal role of an ESOP, also if you could help why it's a specialty in the legal space, right? And why other attorneys that aren't familiar with ESOPs might not get into, because I think that's, Steve and I have talked a lot about other advisors that are not familiar with ESOPs, whether it's an attorney or a CPA or a banker, generally don't gravitate towards them because it's not their specialty. So as you're explaining that role, it kind of also compare and contrast that to just, maybe a general M&A attorney and how that would be different.
Sure. Well, happy to do both. It actually, the one question feeds into itself. So what I usually tell clients who come to me and say, I've heard about this ESOP what does it entail? I basically have the same answer for everyone, which is when you're thinking of doing this journey called an ESOP, you're not just selling your company, you're also creating a new benefit plan for your employees. And those are two distinct, separate things that I find equally important when we're spending time with folks. Is we're stressing as much as trying to understand the benefit that you're putting in for your people, as opposed in addition to all the complexity of selling your company. That, Ryan, if you've gone through this personally, you understand it's not easy to sell your company. There's a lot of twists and turns and things that you need to worry about. You got to do both. So I think what ends up happening is a lot of the attorneys that understand employee benefit law, and an ESOP is an employee benefit plan. It's governed by both ERISA as well as the tax code. A lot of the lawyers are very astute and know how to navigate those statutes and design a plan, but aren't transactional people, don't know how to buy and sell a company. When you have the people who are doing general M&A, who are buying and selling companies to private equity or to selling just basically to the employees without an ESOP as part of the structure, or to another company in the industry, you don't have to worry about the benefit planning. So I think where you end up having somebody like me who's a little bit of a unicorn is I was trained to understand employee benefit law before I was trained how to do a transaction. And once I was trained to do a transaction and advise people on the regular M&A world of finance and transactional issues, I was able to take those two disciplines and match them together and be a well-rounded professional. So I do think that's one of the reasons why attorneys maybe don't do them, because they don't have the one side or the other side of the expertise. But I do think, again, if you're thinking through, what do I need to do to become an ESOP program? You need to not just focus on selling your company, but you also have to focus on the benefit aspects of it. I know we're going to talk a little bit about some of the technicalities of that as we go along today.
That I love how you broke that apart into those two buckets. And David, I got to ask you, as an attorney working on a transaction that's an ESOP, where it's mainly reliant on the cash flow projections of the company post ESOP, how that might be different than a typical M&A attorney who it's like, hey, let's get the synergies, let's get the asset sale done, and let's jam whatever the sale is into another company. The context behind this, David, is I did a presentation years ago, and there was like 150 people, entrepreneurs in the audience, and I was giving my presentation and started talking about M&A attorneys and like the legal counsel, how that's important. And some guy raised his hand. He goes, "I don't know any attorneys that know what working capital means." And so, and I'm not projecting this towards you, but like with an ESOP and the future cash flow projections, what's your level of understanding, like not level of understanding, but your involvement in like the financial projections too? Does a kind of the joke but also question make sense?
Yeah. Oh, sure. Well, I do think if you're going to be a advisor in a business that is based on financial type of analyses, what does cash flow or working capital look like? You have to have somewhat of a rudimentary understanding of how that works. Actually, when I was in the mid 90s, when I was learning the ESOP business, I was actually on what I'll call the buy side of the transaction. I was actually working for a bank that was a trustee or the buyer in the transaction of an ESOP. I made a conscious decision. I was a finance major in college, but I was gravitated toward law because my finance professor said, you're a really nice guy, but maybe you should think about doing something else.
That's awesome.
Business law was a good intersect. But I actually went to one of the local universities here in Chicago, and I took a graduate level financial statement analysis course.
Oh, cool.
I do think you do need to have some level of understanding. There are other parties in this transaction besides the lawyers, the financial advisors and the investment bankers. That's their job. But if you're representing somebody who is relying on you to be their advisor, you need to have that understanding and at least know how to navigate some of those issues.
I appreciate the response, and I wanted to do that to put you in good light, right? Because so that way people are sitting there going, okay, this is actually a legit conversation that we're going to be diving into.
Right.
So,
And
Steve, you want to go? Yeah, go for it, Steve.
Yeah, David, you talked about being on the buy side, and I think you were on the buy side for quite a while, and I know you do both buy side, and you also help business owners as well. Can you talk about a little bit about the difference between your role on the buy side and on the sell side?
Sure. Well, getting back to Ryan's original question about needing to understand from a financial perspective, one of the fun little, I'm not a theater person by any stretch of imagination, but I saw a movie or a play. It was called Other People's Money. An
Nice.
ESOP, you're using, in a regular M&A, you're using other people's money. In an ESOP, you're using basically your own company cash flow to finance it. So on the buy side, we are creating a buyer. When you're doing an ESOP transaction, there is no ESOP unless you create it. And that ESOP typically, not always, but typically has $0 in it. It hasn't been funded. So in order to be able to do this transaction on the buy side, the sell side has to create the buyer. So that leads to a lot of potential conflicts, as you can imagine. It's hard to be a buyer and a seller in the same transaction. So on the buy side of an ESOP, there is a person or an institution called a trustee. An ESOP is an employee benefit plan. It's funded through a trust. And every trust that you form, whether it's your personal trust to own your assets or an ESOP trust, has a fiduciary or a trustee in this case. So when I was a trustee, I was actually doing the work of a trustee. And now when I am a practicing lawyer representing a trustee, we're there to make sure that everybody's acting independently. You want that trustee to have a lawyer that's separate from the company's lawyer. You want to have that trustee have a financial advisor that's separate from the company's financial advisor to avoid those conflicts when you're essentially creating a buyer for your own business. And then on the sell side, it's typically what you would expect from any M&A transaction. There's a set of legal documents that need to be drafted and reviewed. There's usually a letter of intent that needs to be negotiated. ESOPs are a little bit of the bizarro world of M&A. Normally, a buyer would submit its own term sheet for the business it's buying. It's flipped around in an ESOP transaction. So the sell side actually creates the term sheet and advises the selling shareholders what should or should not be in that term sheet. And we actually have a real negotiation. So we're actually facilitating the negotiation of that term sheet and all the deal documents as we go along, in addition to talking about getting back to the benefit plan design, focusing on giving advice to the sellers about what the plan should look like and what the ESOP will look like after we do this transaction. So it's really more what I would find traditional M&A with a twist if you're on the sell side.
I like how you broke all that down. And in Steve, you wanted to talk, I know we wanted to talk a little bit about the legal documents that are necessary. Do you want to, I don't know if you had a very specific pointing question that you had for David before we keep rolling.
Yeah, no, I think he led right into it. It's on the sell side that, or is it on the sell side or the buy side that the documents are being created?
Usually the sell side creates those. Again, backwards. It's a little bit backwards from regular M&A. If a private equity firm is coming in to buy you, you can bet your bottom dollar they're not going to let you draft the documents. They want to use their forms and their procedures. But the fact that the ESOP doesn't exist and it's being created specifically for this transaction lends the sell side to be a little more active in these transactions.
And so the transaction is over, and there's, like any other trust, there's a trust document, some sort of legal document, and that's kind of how we want to continue on the conversation. We have this legal document, and so let's talk a little bit about what's in the legal document and how it operates. But before we get there, a lot of people say, we hear, ESOPs are complex, and if we take the transaction out of it, people also say, you know what, this is the ongoing costs and the ongoing administration and all of that. Can you talk a little bit about that legal document, not necessarily the administration, but what your role becomes or what people should know about a legal document in an ongoing benefit plan and the management of it?
Sure. Well, I tend to find most companies have some sort of retirement plan.
Right.
It could be the traditional 401k plan where it's when the employees say, I'm going to take $100 out of my paycheck every week. I'm going to give it to this person who's administering the plan, and I'm going to tell you how to invest it. So that's pretty common this day and age. And it could look like a 401k plan or a simple IRA. Some sort of employer funded retirement benefit is relatively normal these days.
And all
So an
those,
ESOP,
David, all those things are just wrappers around the money, right? It's just a tax wrapper based on how that money is being treated, but it's just people funding a plan for retirement.
that's correct. And that wrapper is created because the government has rules associated with how you manage retirement benefits. To rightly so. We don't want people's retirement benefits scattered to the wind or not regulated. We want to have that regulated. And again, that goes to the Department of Labor, regulates the statute called ERISA. There's an acronym for ERISA. I won't ruin it for everybody, but you can look it up. And the tax code, the IRS is responsible for that. But yes, the document is the wrapper for those benefits to comply with all the laws that, again, if you have a 401k plan, you're probably pretty familiar with those rules. There's limits on how much you can put in a year. There's certain restrictions on how to invest the money. There's certain restrictions on when you can access the money. It's meant for retirement. It's not a savings account where you just withdraw it and pay your bills.
Mm-hmm.
It's supposed to be for funding long-term retirement, and it's usually, but not always, funded by the company, either from the employee's wages where they tell us to take it out, could otherwise go to the employee, or the company makes a profit sharing type of contribution in excess of what the employee decides to put in of their own paycheck. So I'd say about 90% of the rules and regulations that the ESOP is subject to is exactly the same as all the rules and regulations that a lot of employers are familiar with when they sponsor those retirement plans. Where we add value and the people in our ESOP community add value is the other 10%, about how to manage a benefit. And remember, the ESOP is an acronym for Employee Stock Ownership Plan. The main investment of an ESOP is stock in the company, and these companies are mostly, but not always, privately held businesses where you can't go on the street corner and buy and sell the stock. So a lot of those 10% of the special rules are based on the fact that the investment in the ESOP is the stock of the company that's sponsoring it. That's where most of our counseling comes in when we set up the ESOP, is how do you manage a program where the main investment is illiquid stock of your business?
Mm-hmm. And maybe you could, because I know, Steve, we're going to be getting into like how employees are vesting and how they get their shares and a lot of like kind of the operational stuff. But like before we do that, David, the employees they're not shareholders of the EIN number. The trust is shareholders of the EIN number, right? So how do the employees actually have ownership in this trust document or in this retirement? Because you're doing such a good job at describing the benefits. So how do the employees actually mechanically own ownership or have a vested interest in that document or in that trust?
That's an excellent question. It kind of leads into, again, maybe why there aren't as many ESOPs as there should be, is because there is this lack of understanding about what rights the employees actually have when they own stock. And that's a common objection we get is, I do an ESOP and my employees are going to have access to our financial records and know what the owners make and what kind of car they drive.
Forklift truck driver is going to be making strategic decisions, etc. Right?
Correct. But and that's one of the things where we try to be, we acknowledge the question, we acknowledge the sort of trepidation of having that, putting the fox in the hen house, so to speak. That it's really not what ESOPs are all about. An ESOP, and the stock inside the ESOP is owned by the trust, not by the individual employees. So there's one shareholder. When you have 100% owned ESOP owned company, there is one shareholder. It's the ESOP trust. It's not all the interests of the employees. So they're what we call beneficiaries or beneficial interest holders. So they have the right to the economic value of the stock, but except under very limited circumstances, they have no rights to governance or any special information other than the value of the investment that's been made for them. And that's where usually the discussion stops. And if we have to go even further about corporate governance generally and what do shareholders vote on and what do shareholders do versus the board of directors or management, we can go much further, and I'm happy to do that here if you'd like. But that's really where it starts and ends, and hopefully that's where the discussion says, okay, now I get it. We're just giving them a benefit. We have to tell them every year what their benefit is. We generally don't have to give them much other information unless we want to. And that's up to the management team to decide how much and how transparent they want to be with their employee owners to say, we'll give you this information because it's the right thing to do or it's part of our strategy. But you don't have to do any of that.
And I like how you brought out that trepidation or almost a myth that I don't think gets talked about enough, which is we talk about why ESOPs aren't more prevalent. There's a lot of reasons, and that's one that doesn't always come up as the worry by the owner or by the management team that the governance will change. So I'm really glad that you brought that up. I think one of the other things that really keeps people from thinking deeply about ESOPs is that complexity piece and how the operation all works. And when I used to be a third-party administrator for 20 some years, I tried to make it as simple as possible and go back to what you said, which is this is nothing more than a benefit plan.
Mm-hmm.
And at its most easy point, it's a profit sharing plan. It's before 401k plans were involved. We had a profit sharing plan. The company would say, we are going to share X amount of profits this year. And back then they invested it for you, and they gave you a statement every year and said, here's what it's worth. It's really where the ESOP's been around since the 70s. Can you just talk a little bit about that basic profit sharing? Because the question always is, well, how do my employees get stock if they're not going to put money in?
Mm-hmm.
And I think that's the answer. But I would love to hear more about what you think about that, how to explain that easily.
Yeah, well, I think you did a fine job right there, Steve. But going back to something I said earlier, ESOPs generally are created out of the air, meaning when there's a transaction to be had, where does the money come from? Because if you're a selling shareholder, you're not selling your stock for air. You're selling it for something.
Right?
Right?
Yeah, exactly. I love it.
The money's got to come from somewhere. And there's really only three places the money can come from. It can come from the employees taking other retirement dollars and moving it into the ESOP to buy stock. We don't see that a ton because it's got its other set of complexities. That's a transaction where you're offering, you're doing a sale of securities, and there's a securities law component to that. It's not something that can't be managed, but we don't see that very often. The other place where the money can come from is from a commercial bank, or even perhaps the selling shareholders themselves making a loan to the ESOP and basically giving the shares over to the ESOP in exchange for a note that the sellers will take, and now they become a creditor of the business, not a shareholder. And I guess there's a third way, as the company could just start putting cash into the plan from its corporate cash, like Steve said, a profit sharing plan, and then work with the trustee to say, we think now is a good time to buy stock of this business, either directly from the shareholders themselves or from the company itself, and deal with the shareholders, reducing their ownership at that point when the ESOP buys more. It's a dilutive issuance. So there's a lot of different flavors to it, but it usually means the company or the sellers are funding the benefit for the employees over a period of years.
I love how you broke that down. Very simple of how the funds are available, because if the ESOP is coming out of thin air, created, now we got this wrapper, it's getting funded through one of those mechanisms. So then, David, how do the employees actually get their benefit, and what type of benefit is it?
So it is a stock interest in the business. Depending on which way we fund it, whether it's just a cash contribution buying stock or a loan, that stock will be what we call allocated or put into an account that's maintained for each participant within the plan. And that's that wrapper again, the rules and the administration that goes along with it. The business that Steve was in for many years was accounting for what share level each participant has when they're an employee. You have to meet certain requirements to enter the plan. You usually have to work there for at least a year or 6 months to get what we call 1,000 hours of service. That's a typical entry requirement. And then year over year, especially if the stock is bought with a loan, it doesn't get put into the accounts right away. It gets much like a mortgage. When you pay down your house, when you have a mortgage, you own the house. The house is in your name, but until you pay off the bank that financed that mortgage, you only really own a small piece of that house. So we have a mechanism within the ESOP, much like that mortgage analogy, where we hold certain shares in what we call a suspense account. And then that suspense account does not belong to anybody other than the bank that financed it, or the selling shareholders who financed it, or the company who financed it. And then over time, as that loan is repaid, like a mortgage loan, a smaller percentage of that house, or in this case, the shares in suspense, are put into the accounts of the people who are participating in that plan during that particular year when you've made those payments. So it can be done upfront, it can be done gradually, or it can be a combination of both. So you get a little stock up front, and then you have to wait to get more. And as I like to say, my favorite saying, you got to be in it to win it. So if you stick around for a long period of time and you stay in this company for 15, 20 years, you're going to grow as the company's stock value grows, and your retirement will be funded that way.
Very well put, David. And when is it safe to say that the equity those shares that are going into that suspense account, and then they're released once the equity once that valuation is done, and say, hey, like, this is the equity that's been created this year. So let's say it's $1 million in equity. How, like, and maybe this is kind of where you're going into, where there's certain like stipulations of flexibility of how employees get, like, how fast. Maybe you can expand on this, or Steve, feel free to jump in. Is like, there's the cliff where it's like, hey, you don't get any vesting as an employee until 3 years, or there's like a gradual one, and there's the same kind of, payout when someone leaves or quits or retires. So like, if there's a chunk of like $1 million in equity that was that was created or put into the accounts one year, how do the employees get it, and then how does it actually get bought back? Maybe I'm going too fast, Steve, or Steve, you have any?
Maybe a little bit too fast. I think the question that you're going with is, I love the mortgage analogy. If there was 10 of us, if there's 10 of us in an ESOP, or 100 of us in an ESOP, if those same 100 people owned a house, it's really, like David said, nothing more than we make a loan payment and it releases equity to all of us. It's just that usually it's a husband and a wife that are getting that equity. Same thing in an ESOP. The question that you're going after is, yeah, that's fine. We released equity to the participants, but do they actually earn it right away, or how is it allocated?
How is it allocated, and when do they get it? Right?
Yep. Yeah. So Steve, how it's allocated and when it's vested, that brings you back to your your prior profession, right?
Exactly.
So either one of us, I guess, can take that. So do you want, me to go for that one?
You are the guest.
Okay, well, thank you. So I'm trying to give Steve props. This is what Steve's business was for many years. But long and the short of it is, there's this is where some of the complexity comes in, but not necessarily foreign to business owners, because a lot of those rules apply to 401k and profit sharing plans too. So on an annual basis, there's a couple of methodologies in an ESOP to be able to, what we'll call, allocate that annual benefit, that mortgage, that release of that piece of that pie that the mortgage allows you to release every year. The way the standard way it's done is you allocate it based on relative compensation with certain limits. So if Steve makes $1 and I make $1, and there's 100 shares to allocate based on the release that year, because he made $1 and I made $1, he'll get 50% or 50 shares, and I'll get 50 shares. That's the basic methodology. There's other kinds of more complex methodologies that you can use in an ESOP. You can't quite be as flexible in an ESOP as you can for other plans for a variety of reasons, but you can use a points allocation system where you can look at what the age and what the tenure of the employees are, and and give everybody a certain number of points, and then allocate the benefits based on those points that you get relative to someone else. It gives a little bit more benefit maybe to some of the longtime people or the people who are a little closer to retirement. But again, those are the complexities, and those are the kinds of discussions we're having with the sellers when they're setting up a plan to figure out what their objective is. The simple way is to do it across the board, equal based on compensation. You can use these other formulas if you want to get a little more funky in your design and have an objective to be able to benefit a little bit more to a certain group of employees.
And I think the important part of that allocation based on compensation, and one of the things that helps sell the ESOP concept, is that, we think of this as broad-based ownership, which is the reason ESOPs are so great. And the reason I've been doing this for so long, and David, all of us do this, is that we give equity to every single employee, no matter what their job title is, as long as they've met those eligibilities. So typically a full-time or three-quarter time employee. Having said that, what business owners sometimes have a problem with or worry about is, well, my management team is going to have the same equity as my person at the front desk that's only been there for 2 years. And that's not the case. You allocate those shares based on compensation. And so you may have a management team that owns some shares along with the selling shareholder. They can sell their shares and get them back at a higher rate because they have the higher compensation. So I think that's an important
Which
thing.
Also, by the way, just it's and if you think about it, hypothetically, not hypothetically, the way that compensation is supposed to work is that we all got a corporate structure. The higher paid you are, the more value you should bring to the organization. So in theory, it should. That's what I'm saying. This whole the CEOs of the public companies, 3,000 times the lower workers and all that. That aside, in a privately held company, everybody's value should be dictated based on the salary that they're getting and the value that they're contributing. So in theory, they're getting the value that they should have delivered to the organization as well.
Correct. And the government is they're smart about it too. I reference these caps. There's a certain cap on the compensation you can use for determining benefits a year. So if you've got a CEO that's making $1 million, they're not going to get $1 million of the value allocated to them. It's going to be capped at a certain level because, again, we want this to be a broad-based benefit to benefit all the employees of the company. And if you're an owner who cares about your employees, that's going to be your objective. And
what is the cap, David?
You're going to put me on the spot.
I think wasn't it like 280 or something like that? This is a few years ago.
305. It goes up every year. I think it's 305 or 310 for 2022, but it's almost 2023 now, so they're going to probably change it.
Yeah, with a little bit of inflation behind our back, right? But isn't there some executive comp plans that you can do to help with some of if there's a gap between the $1 million and that cap? There's some typical phantom stock program that you could put in place to help incentivize those key executives as well, right?
You always have to keep in mind that a company, after an ESOP is done, has to operate successfully, and you have to recruit and retain your executive management talent and compensate them according to what they need to be compensated. So an ESOP is just a component of the compensation program. So Ryan, everything you're saying is there are other aspects of the compensation structure for your management team that outside the ESOP will be able to provide those incentives. So yes, you're right on track.
And then go ahead, Steve.
I gotta say, so that brings us to, probably a podcast we could do for an hour and a half would be the last part of an ESOP, and the part that probably gets discussed the most. And that is, we've done the transaction, we've allocated the shares over a period of time, and people don't stick around at their job they're not there for 25 years. Some are there for 2, some are there for 30. But at some point, you're going to leave the company, and you have an account balance that shows the stock. That distribution process is the complex process, and every legal document is different. But there are some basic things that I think David could do a really nice job of explaining, at a high level to help people understand, how this operates. And it really isn't, at the core of it, it really isn't that different than any other plan.
Correct. And, I have to give credit to the predecessors, the attorneys, the tax advisors, the people who wrote the tax code that governs ESOP. There was a lot of thought put into that topic.
No kidding.
Because, again, we're talking about the main investment being illiquid stock of a privately held company. So this concept that Steve's getting at is we call it in the biz repurchase obligation. In order to be able to provide the benefit that to the employees when they have an event that allows them to get their money, that stock has to be basically rebought by the company or the ESOP itself, and that comes from the corporate profits of the business. So that obligation to buy out those shares at the time of the event that triggers this right for distribution, we call them the DDR events: death, disability, retirement, and then you add a T on there, regular termination. Either you quit or you're fired. So a couple things happen. Number one, we didn't really talk about it, but when I said you got to be in it to win it, most ESOPs have what we call a vesting schedule. So in order to be able to be entitled to get a distribution, you have to be there a certain number of years. The standard vesting schedule for an ESOP, much like a regular profit sharing plan, is what we call a 6-year graded schedule, where you're basically 0% vested for the first 2 years of your participation in the ESOP, and then you vest 20% over the next 4 or 5 years until you're 100% vested after year 6. So if you're somebody who's been there for 2 years and you quit, you may not have a vested interest in that business, in which case that benefit will go to somebody else who's going to be there longer.
And David, there's flexibility with that, like whether it's all that whole 6 or someone kind of, that's where in the ESOP feasibility, you can kind of design how fast you want to help people vest in, right?
Yeah, the 6-year is an outside limit. You could use what we call a 3-year cliff, which goes to 000 year 3 or 100%.
Got it.
You can go anywhere in between. We have clients that sometimes say with the new ESOP, we're going to give 1 year of vesting credit for every 10 years of service you had before we had an ESOP.
Awesome.
Just to give a little more juice to the people who have been there a long time, but maybe are closer to retirement. And then you get to that point where you have the DDRT events, death, disability, retirement, or termination. When do you get your money? And the government, again, I very, very smart about this, is to say this repurchase obligation could become burdensome if you have a big group of people leave it in 1 year. So what they set out is basically the default rule is if you die or disabled or retire, and usually retirement is age 65, it may have 5 years of service, you can pay them out 1 year after the event. You can delay the payment for at least a year to give yourself a little bit of flexibility. For anybody who terminates for any other reason, you can wait up to 5 years to pay them. So again, you're spreading out that liability.
Spreading out, or can you just defer it completely, all the payments for 5 years?
Well, if for somebody who is not death, disability, or retired, or doesn't have any other events, there's all sorts of other triggers that are probably beyond the scope of this call. But there are other ways to get your money. But the main mechanism to push it out is that 5-year window.
Got it.
And then you can even go as further. That's what we call timing. You can also have a form of distribution, which is installment payments. So instead of paying somebody out in a lump sum, if you wanted to spread out those payments over a period of 5 years, even in that 1 year window or death, disability, retirement, you could still pay somebody out over 5 years. So we've been given the flexibility within the tax code when we deal with ESOPs to deal with this repurchase obligation and to spread it out and to plan for it. So you can certainly have those as your default rules and then accelerate or have a policy that says if your benefit is less than $20,000, we'll pay you over 2 years. You can be very, very flexible, and you can change. The other thing you can do, which you can't do for other plans, the law allows ESOPs to be able to change those policies over time. We typically recommend that when you make a change in a policy, if it's more restrictive, you do it on a prospective basis. Anybody who's got a vested right to get paid, you don't want to tell them, well, we're not paying you now. But for anybody in the future, you can move that over and change your policy to basically pay people out over a longer period of time or make them wait longer, up to that 5-year window. I
just got a little flashback of the times in my career where I've changed the comp plan for a couple dozen sales reps, and the implications of that. So I think going in there with a lot of thoughtfulness is important. David, I wanted to stress test this this idea against you. So like, and not the idea. I always get these comments of like, hey, you know what? Everybody, there was so much of an ESOP account with the executives. We were forced to sell because the repurchase obligation was so high. What I've been saying so far, and I want you to just totally tell me that I'm wrong if this is the case, because this is what I've been saying is that sounds like absolutely terrible financial planning. Because if you're growing and you can have all three financial statements project out and you have your income statement, balance sheet, and cash flow statement tied to your strategies, you should know exactly who's going to be retiring and then how you're going to fund that. And so it's just poor planning. But I might be wrong. And like all I could think about is in our training, we talk about the Yellow Springs example where everybody vested immediately and everybody, took their money immediately. This is probably before the tax codes were changed. And the whole thing went bankrupt by accident. That was that like early 80s. So my whole thought is like, it's just poor planning. If for some reason the ESOP wasn't able to fund it, it was poor planning or economic travesty with the company. Am I right, wrong? What are variations of it?
I think you and Steve could have a whole podcast on this concept of repurchase obligation and ESOPs. And in point of fact, we go to conferences all the time, and there's usually about 5 or 6 sessions out of the 20 that you do where somebody's talking about some level of this repurchase obligation and how to manage it. You're exactly right, Ryan. It's the whole it's the old saying, failure to plan is planning to fail. This should be all when you start an ESOP, it's incumbent on you, just like when you start your business. When you start your business, you should always think about how I'm going to exit it. When you start an ESOP, you should always be thinking about how I'm going to afford to satisfy the repurchase obligation, because the reason why you're doing it at its core, going back to the first part of our discussion, which is we're not just doing a transaction, we're setting up a benefit program. This is the obligation of the employer to have a benefit program that can be funded, long-term sustainable, and if it works right, you can have a multi-generation ESOP-owned company that has in its DNA that we have part of our cash flow is used for ongoing repurchase obligations. So it can all be managed.
David, I just love it because all you just described is a good business. like I keep going back to like, if you buy a business and grow it, or if you have one and you're growing it, you should want to know when and how you're going to get paid and who's going to do it anyways. And you want to create value. And like, it goes back to, it's not that more complicated. It's just, it's all predicated on building a good business that has good, healthy cash flow and has a plan going forward.
Correct. Couldn't have said it any better.
Steve, other than us doing this for another 2 hours about the repurchase obligation or something like that, is there anything that we're covering as relates to vesting, payouts? I'm trying to think if there's anything.
No, I think we covered all the topics that we had thought were important. Like you said, we were trying to do a little bit of a 201. A lot of people know, employees get stock. They don't have to put money in to do it. They can take the stock out when they leave. But if someone wanted to know, much deeper than that, I think David's done a great job of teaching us how all of that works. And I think your point about repurchase liability is spot on, that it is just planning. And every once in a while, economic downturns happen and things happen, and all of a sudden that causes issues. And an ESOP causes different issues in that economic downturn than others. And that would be that there's this repurchase liability along with trying to manage your business for this downturn. So we can't pretend that it's not there in an added complexity, but I think that's the only time that the planning doesn't work. If you're planning, we can continue on with an ESOP. I think every once in a while we get this double whammy of a bad, something happens to your business, and at the same time you have people leaving. Luckily we have those rules in place, but we do see that every once in a while. Unfortunately, those are the ones that hit the headlines when that happens. I can think of a couple, just a handful of them that I've been involved with or where that has happened. And yeah, it's no fun, but.
I got a real life story for you. There was a company I know that is in the trade show events business that did an ESOP in January of 2020. By the way, the company still would have been in a shitload of hurt regardless of whether there was an ESOP or not, right? It's just a bummer in general.
Right.
Yep. I think I know that one, but
you think you know that?
I have a feeling I know that one, but we won't tell tales out of school. That's not what we do.
Well, I appreciate you so much coming on, David, and I appreciate your clarity and how you describe a lot of the complexities of this. What is the best way for the listeners to get in touch with you and find your firm?
pretty easy. We're creatures of social media these days. So either LinkedIn, I have a LinkedIn profile. You can find us on our website. It's www.lplegal.com. And I believe, Ryan, you have my contact information. Most of these days, the office phone works, but it also rings to my computer. So that was our technical difficulty at the outset. And I have a cell phone that I'm pretty rigorous about checking. So I'm pretty easy to find, and it was my pleasure to be here. Thanks, guys. I appreciate it.
Yeah, thanks, David. I appreciate it. Thanks, Steve, for setting this up.